Be seated.
I understand that there is a verdict. You may bring the jury. Thank you. Madam Forlady, if you'll stand for me. Have you reached a verdict?
Yes, sir, we have.
Is it unanimous?
Yes, sir, it is.
All right, if you will pass it up to the clerk, who will pass it to me. And you may be seated. The defendant will rise. Madam Clerk, you may publish the verdict starting with the back, not with the, let's see, I'll tell you again. Starting with the back, flipping them over one by one.
Docket number 2022 GS 15-00592, the State of South Carolina, County of Colleton, in the Court of General Sessions in the term of 2022, July, the State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116. Okay. Guilty verdict. Signed by the forelady, 3/2/23. Docket number 2022-GS-15-00593, the State of South Carolina, County of Colleton, in the Court of General Sessions, the July term of 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116, verdict guilty, signed by the forelady, date 3/2/23. Docket number 2022-GS-15-00595, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code -16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, date 3/2/23. Docket number 2022 GS-15-00594, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code 16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, 3/2/23.
Thank you. Madam Forelady and members of the jury, if that is the verdict of each and every juror, please let it be known by raising your right hands. All right, thank you. Any individual polling requested? Madam Clerk, you'll need to individually poll the jury according to their juror numbers.
Number 193. Was this your verdict?
Yes, sir.
Is it still your verdict?
Yes.
Juror 254. Is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 326. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 530. Was this your verdict?
Yes.
Is this your verdict?
Yes.
Juror 544. Yes. Was this your verdict? Yes. Is it still your verdict? Yes. Juror 572. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 578. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 589. Was this your verdict? Is it still your verdict? Juror 630. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 729. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 826. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 864. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Your Honor, the jury has been polled.
Thank you. The jury has been polled, and the verdict is a unanimous verdict. If you will bring the alternate juror out and have her have a seat in the audience, please. You can stand there or you can sit back there, whatever you prefer. Okay. Are there any post-trial motions?
From the state, Your Honor.
We would just renew our previously argued motions for a directed verdict at this, on the grounds, on those grounds we would make a motion for a mistrial and to set aside the verdict.
By the state, response.
Your Honor, based on our previous arguments, we would submit that the case properly went to the jury and the verdict is proper, and we'll rely on those arguments.
We've been here now 28 an first few days of jury selection, and the remainder receiving testimony, an overwhelming amount of testimony and evidence that was presented to the jury for the jury's consideration. As I indicated to the jury during the jury charge, or the charge on the law, that this was a matter solely for the jury to determine. The court found at the end of the state's case that there was sufficient evidence to find the defendant guilty if the evidence was believed by the jury. Likewise, at the end of the defense's case, when the motion was renewed, the court found that the evidence was sufficient for the jury to find the defendant guilty. The jury has now considered the evidence for a significant period of time, and the evidence of guilt is overwhelming, and I deny the motion. Mr. Murdaugh, you now having been found guilty of 2 counts of murder involving your wife and your son, 2 counts of possession of a weapon during the commission of a violent crime, the burden now comes upon the court to impose a sentence. Given the lateness of the hour and the victim's rights that must be taken into consideration and complied with under the Victim's Bill of Rights, and consider what I would anticipate to be a number of people who might have something to say regarding sentencing, we will defer sentencing to a later date. Of course, the minimum sentence for murder is 30 years. The maximum sentence is life imprisonment as to each count. And on the weapons charge, the sentence is up to 5 years, or 5 years, which has to be concurrent if a life sentence is imposed. When would you all like to reconvene for sentencing? I would like to give everyone an adequate opportunity to prepare for it.
State will be ready at 9:30 in the morning, Your Honor.
We could do it at 9:30 tomorrow morning also.
All right. The defendant is remanded to the custody of the Colleton County Sheriff's Department. And he may be taken away. Madam Floor Lady and members of the jury, I want to thank you on behalf of the citizens of the state of South Carolina and your fellow citizens of Colleton County. You did not volunteer for this service. You were called upon by being summoned to appear, and Providence have brought you to this moment in time and these weeks in time. I know that all of you have been here at great sacrifice, particularly the juror whose job was on the line until a miracle happened, I guess, that allowed him to be able to leave rather than to stay rather than leave after 2 or 3 weeks. But I want to thank each one of you all individually and collectively. It's not often that you're called upon to sit in judgment of the actions of your fellow man, that you all responded and gave due consideration to the evidence. I will make no comment now as to the extent or the overwhelming nature of the evidence, but certainly the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointed to only one conclusion. That's the conclusion that you all reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion as you saw the law, as you saw the facts. Now that you've served for the next year, you're not eligible to serve again. Now, of course, many people never get called upon, but you're not eligible for the next year, and for 2 additional years, you can be exempted from service because no person is required to serve on jury duty in this court more often than once every 3 years. Tomorrow morning at 9:30, we will reconvene for sentencing. You all have no role in that because that's solely up to the judge, to me. You're welcome to come back if you want to and be a part of the audience, if you like. I also want to thank the alternate juror who was locked away in a room by herself for these hours, who's hung in there during that period of time. I want to thank you as well. Madam Clerk, what do you have to tell your jurors?
Thank you for your service and what the judge said as well. And I think we can release them tonight and bring them back in the morning.
No, they're off jury duty. They can come back if they like. And you don't have to if you don't want to. Typically, I've seen jurors wanting to see the end result of a case once they've invested a lot into it. It's really an amazing thing with juries. Quite often, at the start of the case, jurors are really like, whoa, why am I here? I wish I wasn't selected. But as time passes and the jurors become invested and really committed to the case and committed to seeing it through, and are very disappointed when they are not able to see it to a conclusion. And then along the way of serving, you end up finding out quite a bit about our judicial system, and learning quite a bit, well, about human nature for sure, but also about the presentation of evidence and hearing from expert witnesses and really learning a lot of things that you'll be able to take with you when you leave jury duty. To Madam Forelady, I don't know if you were hesitant initially or not, but you have stepped up to the plate and done a great job of leading the jury as well. And thank all of you. So the jury is dismissed. Now, one thing before you go, of course, we have invested a lot in maintaining the privacy of the jury, of each one of you. And you are free at this point to discuss the case with anyone. Given the high-profile nature of the case, I'm certain that the many people in the media will probably want to communicate with you, but they have no means of contacting you because under order that I issued, the identity of the jurors must be kept private. And if you decide that you want to speak with anyone, local, state, nationally, or internationally, that's your prerogative. However, should anyone harass you, please let me know and I will address those issues. If anyone through the somehow or another discover your identity and harass you, and rest assured I will intercede on your behalf. That having been said, you are free to communicate with whomever you might want to concerning the case from now on. And so with that, thank you, and you all are free to go. Yes.
If I could have you go to my email, and I'm going to get you for just a few minutes.
All right. And as is my practice, I'll speak with the foreperson before you leave the building after talking to them back there. Be in recess till 9:30 tomorrow morning. Thank you. Murdaugh, if you would come to the court for sentencing. This has been perhaps one of the most troubling cases, not just for me as a judge, for the state, for the defense team, but for all of the citizens in this community, all the citizens in this state, and as we've seen based on the media coverage throughout the nation. You have a wife who's been killed, murdered, a son savagely murdered, a lawyer, a person from a respected family who has controlled justice in this community for over a century, a person whose grandfather's portrait hang at the back of the courthouse that I had to have ordered removed in order to ensure that a fair trial was had by both the state and the defense. And I've sat through the trial. Not only have I sat through the trial, but also as the presiding judge of the state grand jury, sat through and participated in the issuance of search warrants of various sorts, bond hearings, and have had to consider many things. And we have this case, and I'm also assigned to preside over 99 others, at least 99 other cases. Though testimony has come up regarding many of those other cases, I will not make any comment with regard to any other pending matter, as I have been assigned those cases as well. It's also particularly troubling, Mr. Murdaugh, because as a member of the legal community and a well-known member of the legal community, you've practiced law before me, and we've seen each other at various occasions throughout the years. And it was especially heartbreaking for me to see you go in the media from being a grieving father who lost a wife and a son to being the person indicted and convicted of killing them. And you've engaged in such duplicitous conduct here in the courtroom, here on the witness stand, and as established by the testimony throughout the time leading from the time of the indictment and prior to the indictment throughout the trial to this moment in time. Certainly, you have no obligation to say anything other than saying not guilty. And obviously, as appeals are probably expected or absolutely expected, I would not expect a confession of any kind. In fact, as I've presided over murder cases over the past 22 years, I have yet to find a defendant who could go there, who could go back to that moment in time when they decided to pull the trigger or to otherwise murder someone. I have not been able to get anyone, any defendant, even those who have confessed to being guilty, to go back and explain to me what happened at that moment in time when they opted to pull the trigger, when they opted to commit the most heinous crimes known to man. In this case, qualifies under our death penalty statute based on the statutory aggravating circumstances of two or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct. Remind me of the expression you gave on the witness stand. Was it tangled?
Tangled web, weave.
Oh, what tangled web what did you mean by that?
And then when I lied, I continue to lie.
And the question is, when will it end? When will it end? And it's ended already for the jury because they've concluded that you continued to lie and lied throughout your testimony. And perhaps with all the throng of people here, they, for the most part, all believe, or 80, 90%, 99% believe that you continue to lie now when your statement of denial to the court. Perhaps you believe that it does not matter, that there's nothing that can mitigate a sentence given the crimes that were committed. You know, a notice of alibi was filed in this case by counsel in November, and we conducted a hearing, pretrial hearing, in which you claimed to have been someplace else at the time the crime was committed. Then, after all of the witnesses placed you at the scene of the crime, at the last minute, or last minutes or days, you switched courses and admitted to being there. And then that necessitated more lies and continued to lie. And I said, where will it end? It's already ended for many who have heard you and concluded that it'll never end. But within your own soul, you have to deal with that. And I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you. I'm sure.
And every night.
I'm sure. And they will continue to do so. And reflect on the last time they looked you in the eyes, as you looked the jury in the eyes. I don't know person who's always been such a gregarious, friendly person and cause your life to be tangled in such a weave, web, such a situation that yours have spun into, and it's so unfortunate because you had such a lovely family of such friendly people, including you, and to go from that to this. You know, your license to practice law has been stripped away from you. You turned from lawyer to witness, and now have an opportunity to make your final appeal as an ex-lawyer. And it's almost, it's really surprising that you're waiving this right at this time. And if you opt to do so, it's on you. You're not compelled to say anything. But you have the opportunity to do so.
As I tell you again, I respect this court, but I'm innocent. I would never, under any circumstances, hurt my wife, Maggie, and I would never, under any circumstances, hurt my son, Paul.
Well, and it might not have been you. It might have been the monster you become when you take 15, 20, 30, 40, 50, 60 opioid pills. Maybe you become another person. I've seen that before. The person standing before me was not the person who committed the crime, though it's the same individual. We'll leave that at that. Before announcing sentence on these cases, with regard to all of the other pending cases, are any of them here in Colleton, or I'm sure some of them are?
Yes, sir.
Half of them, or?
I don't have that in front of me, but there are a substantial number of charges here. There's some in Hampton, Orangeburg, Beaufort, Allendale. There may be others I'm not thinking of right now.
We might have worn out our welcome here in Colleton. They have been, and I'll take this opportunity to thank Sheriff Hill and all of the court officials and really everyone I've met and dealt with while here in Colleton County. Just been great. But without any delay, we're going to schedule some of the other matters. I know Mr. Harpootlian's scheduling is complicated, and you've sacrificed quite a bit to be able to be here defending Mr. Murdaugh, as well as the Attorney General's office, with all the other many things and obligations you have. And to be able to have the Attorney General here, Alan Wilson, for the period of time that he's devoted to being here, along with everyone else, it's been quite a sacrifice. But there are other victims whose cases deserve to be heard, and this case has jumped some of those other cases. Perhaps jumped it because of this case resulting in an assault on the integrity of the judicial system in our state, law enforcement in our state. Even during this trial, the law enforcement have been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice, to be able to deflect the investigation. And as the evidence is pointed out in this case, the looming storm that Mr. Waters talked about, I can just imagine on that day, June 7th, when a lawyer is confronted and confesses to having stolen over $500,000 from a client, and he has a tagger like Mark Tinsley on his tail pursuing discovery in the case involving the death of Mallory Beach, and having a father, for the most part, on his deathbed. I could imagine, I really can't imagine, but I know it had to have been quite a bit going through your mind on that day. But amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life. Not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. Cases you will never have an opportunity to argue anymore, except perhaps your own as you sit in the Department of Corrections. Anything further?
No, sir.
All right, Mr. Murdaugh, I sentence you to the State Department of Corrections on each of the murder indictments in the murder of your wife, Maggie Murdaugh. I sentence you for the term of the rest of your natural life for the murder of Paul Murdaugh, whom you probably love so much. I sentence you to prison for murdering him for the rest of your natural life. Those sentences will run consecutive. Under the statute involving possession of a weapon during a violent crime, there is no sentence where a life sentence is imposed on other indictments. That is the sentence of the court, and you are remanded to the State Department of Corrections. And officers may carry forth on the imposition. Yes, sir. Yes, sir.